I'm Dr. Keanu Sai, and I'm a political scientist specializing in international relations and public law, with particular emphasis on the legal and political history of Hawaii. I'm also a plaintiff in a lawsuit against the Obama administration that was filed on June 1st, 2010, in Federal District Court, Washington, D.C. In order to better understand the lawsuit and its profound impact today, I've produced short vignettes that cover certain sections of the complaint. This particular presentation covers the United States' prolonged occupation of the Hawaiian Islands since 1898. After the Hawaiian Kingdom government was illegally overthrown, two executive agreements were entered into between President Cleveland of the United States and Queen Liliuokalani of the Hawaiian Kingdom in 1893. The President entered into these executive agreements under his sole constitutional authority to represent the United States in foreign relations, and neither Congress nor the courts can intervene without violating the separation of powers doctrine, which would be an encroachment upon the executive power. The first agreement, called the Liliuokalani Assignment of Executive Power, binds the U.S. President and his successors in office to administer Hawaiian Kingdom law. The second agreement, called the Restoration Agreement, binds the U.S. President and his successors in office to restore the Hawaiian Kingdom government, and for the monarch, after restoration, to grant amnesty to those who committed treason. It wasn't long, however, before the Congress took active steps to prevent the President from carrying out the executive agreements, and by 1897, there were two failed attempts to acquire the Hawaii, or the Hawaiian Islands, by a treaty of cession. Despite the non-compliance to the executive agreements, which are violations of not just international law, but also U.S. federal law, Hawaii still remained an independent and sovereign state. In 1898, the McKinley administration was entering into a new era for the United States, the age of imperialism. When Hawaii was unilaterally seized for military purposes during the Spanish-American War, the United States proceeded to treat the Hawaiian Islands as if it were an incorporated territory acquired by treaty, which was a deliberate attempt to conceal the occupation of a sovereign and independent state. On April 30th, 1900, the U.S. Congress passed an act establishing a civil government to be called the Territory of Hawaii. Adding insult to injury, President McKinley appointed lead insurgent Sanford Dole to be the first governor of the so-called Territory of Hawaii. This congressional act also declared that all persons who were citizens of the Republic of Hawaii were to be citizens of the United States and citizens of the Territory of Hawaii, and anyone born in the Hawaiian Islands was considered a national of the United States. Under United States law, the initial population of U.S. citizens in the Hawaiian Kingdom exploded from a meager 1,928 in 1890 to 337,083 in 1950. The native Hawaiian population, which accounted for 85% of the total citizenry in 1890, accounted for a mere 20%, only 86,091 by 1950. This percentage has remained consistent to date. United States law, however, is limited to United States territory and has no force in effect in Hawaii, being a sovereign and independent state. According to international law, the migration of U.S. citizens to these islands, which included both military and civilian immigration, is a direct violation of Article 49 of the Fourth Geneva Convention, which provides that the occupying power cannot transfer parts of its own population into the territory it occupies. In 1946, the United States further misrepresented its relationship with Hawaii when the United States ambassador to the United Nations identified Hawaii as a non-self-governing territory under the administration of the United States since 1898, and Hawaii was placed on a list of non-self-governing territories. Non-self-governing territories are territories that have not achieved the internationally recognized status as an independent and sovereign state. The problem here is that Hawaii should have never been placed on the list in the first place, because it was not only occupied, but it was an independent and sovereign state since 1843. The reporting of Hawaii as a non-self-governing territory also coincided with the United States establishment of the headquarters for the Pacific Command on the island of Oahu. If the United Nations had been aware of Hawaii's continued legal status as an occupied and neutral state, member states such as the Soviet Union and China would have prevented the United States from maintaining their military presence. On March 12, 1959, the U.S. Congress approved the statehood bill, and it was signed into law on March 15, 1959. And on July 28th, 2 U.S. senators and 1 U.S. representative from Hawaii were elected to office. And on August 21st, President Eisenhower proclaimed that the process of admitting Hawaii as a state of the Federal Union was complete, and Hawaii was removed from the list of non-self-governing territories at the United Nations. In 1988, Assistant U.S. Attorney Kamayak raised questions on the legality of congressional action in annexing the Hawaiian Islands by joint resolution. In a legal opinion published by the Department of Justice's Office of Legal Counsel, the opinion stated, notwithstanding constitutional objections, Congress approved the joint resolution and President McKinley signed the measure in 1898. Nevertheless, whether this action demonstrates the constitutional power of Congress to acquire territory is certainly questionable. It is therefore unclear which constitutional power of Congress, Congress exercised when it acquired Hawaii by joint resolution. The commonly understood chain of sovereign title begins with the Hawaiian Kingdom transforming into a constitutional monarchy in 1840. The international recognition of Hawaii as an independent and sovereign state in 1843. The overthrow of the Hawaiian Kingdom by the Provisional Government in 1893. The Provisional Government's change of name to the Republic of Hawaii in 1894. The Republic of Hawaii ceding of sovereignty and land to the United States in 1898, and the ceding of land to the state of Hawaii as the 50th state of the Union in 1959. There is, however, a break in the chain of title that radically disrupts this perceived understanding. There exists no treaty ceding anything from the so-called Republic of Hawaii to the United States in 1898, which means the United States cannot claim to be in receipt of Hawaii's sovereignty and land if there is no evidence of the transfer. And as for the legal status of the so-called Republic and their predecessor, the Provisional Government, well, they're just common criminals, posing as a government when they aren't. Confirming their criminal status is the 1893 executive agreements that bind the U.S. President and his successors to administer Hawaiian law, and for the Queen to grant a pardon to these individuals for committing the crime of treason after the government has been restored. So as criminals, they can't be considered governments. So nothing legally happened since 1893 that has altered or affected the continuity of the Hawaiian Kingdom as an independent state and the binding nature of the 1893 executive agreements. As a result of Hawaii being occupied since the 1898 Spanish-American War, the U.S. military is regulated by the international laws of occupation, which are embodied in U.S. Army Field Manual 27-10 that regulates the U.S. military during occupations. Section 362 provides that military government is the form of administration by which an occupying power exercises governmental authority over occupied territory. And Section 370 states that in restoring public order and safety, the occupant will continue to enforce the ordinary civil and penal or criminal laws of the occupied territory. Section 370 merely reinforces the 1893 executive agreement, where the President has bound himself and his successors in office to administer Hawaiian Kingdom law, which are the civil and criminal laws of the country. During occupations of sovereign and independent states, war crimes can be committed. International war crimes have also been codified under United States law. Title 18, Section 2441 of the United States Code defines a war crime as a grave breach of the 1949 Geneva Conventions. And Article 147 of the Geneva Convention, number 4, defines a grave breach as unlawful deportation or transfer or unlawful confinement of a protected person. A protected person is a national of the occupied state. In this case, it would be a Hawaiian subject. Compelling a protected person to serve in the forces of the occupying power. This would apply to conscription, when Hawaiian subjects were drafted by the United States to fight in its wars since 1898. Willfully depriving a protected person of the rights of a fair and regular trial to be done under Hawaiian law. An extensive destruction and appropriation of property, not justified by military necessity. This would apply to the extensive destruction by the U.S. military of the island of Kaho'olawe that was used as a target range for bombing and naval gunfire since World War II, multiple target ranges throughout the islands, and sunken ships with leaking oil in Pearl Harbor as a result of the Japanese attack. In the Flick trial, a U.S. military tribunal defined war crimes. The court stated, international law as such binds every citizen just as does ordinary municipal law. Acts adjudged criminal when done by an officer of the government are criminal also when done by a private individual. The guilt differs only in magnitude, not in quality. And responsibility of an individual for infractions of international law is not open to question. In dealing with property located outside his own state, he must be expected to ascertain and keep within the applicable law. Ignorance thereof will not excuse guilt, but may mitigate or lessen punishment. Regarding the effects of occupation, the International Court of Justice in 1971 issued an advisory opinion on the unauthorized occupation of Namibia by South Africa. The court stated, all acts done on behalf of Namibia by South Africa without title to Namibia is invalid and illegal, except for registration of births, marriages, and death. That meant everything from business transactions to conveyance of properties were invalid and illegal. Also, under the legal doctrine of post liminium, public lands illegally sold by the occupier can be reclaimed by the returning government from purchasers without compensation. And private lands illegally sold by the occupier can be reclaimed by private persons from purchasers without compensation. In other words, the only acts recognized as legal and valid for over a century here in Hawaii are the registration of births, marriages, and deaths. The international law of occupation also maintains the status quo of an occupied state, which applies not just to the laws of the country, but also its citizenry. These laws also limits the acquisition of citizenship of an occupied state through parentage and not through birth on the soil or naturalization. Hawaiian nationality can be claimed if a person is a direct descendant of a Hawaiian subject on August 12, 1898, irrespective of race, color, or creed, and that all foreign nationals born in Hawaii could only claim the nationality of their parents. President Barack Obama was born in Hawaii to an American parent and acquired U.S. citizenship at birth. He was, however, not born in the United States, which means he was not native born, or in other words, natural born. For more information on the federal lawsuit, Tsai versus Obama et al., visit www.hawaiiankingdom.org.